Hi, everyone. Thanks for tuning in today with myself, Deanna Clark, and Jacob Lundy of the Clark-Esposito law firm. We're here today to talk about the future of legal challenges to the U.S. Food and Drug Administration's Premarket Tobacco Application review, the review process, a recent court decision, which is commonly referred to as the Triton case, the U.S. Supreme Court, and why compliance still matters for the vape industry in relation to FDA. I first want to share my journey with this industry because we came into this at the beginning. Vape products got swept in by what's known as the deeming rule in 2016. And since that time, we've been in the trenches trying to help the industry make sense of what FDA is doing, where the courts are at. And this is vape, yes, but also for the tobacco industry as a whole, including premium cigars, for example. We have been out talking with people in the industry, learning more from organizations. For example, here I am at a conference with SFATA, the Smoke-Free Alternatives Trade Association. To the left of the screen, I'm with the editor-in-chief of B2B Wholesaler magazine, which probably a lot of you watching this know Gary. I have a column in there talking about FDA and other legal issues affecting the industry. I've given presentations. One example was with My Law CLE, looking at FDA laws. And of course, I've spoken with FDA, at TPE and at FDA's campus in Maryland. In this quest to make sense of FDA law and really to protect people has been both Jacob Lundy and Gina Vreeland from my office. We have other videos on our law firm's YouTube channel at Clark-Esposito Law related to not only FDA compliance, but things related to PMTAs, where FDA might come for an inspection, along with that of being an importer of such products. And I want to point out that regulation of vape products in particular is something that I have cared about really since learning about them. And it's because I learned about the potential for adult smokers to essentially wean their way off of cigarettes, which the FDA concedes is the most harmful of all tobacco products, and ultimately come off of it, having seen my grandfather pass away from cancer. So this idea of regulating and maintaining this industry is personal to me, and one that is important to all of us as a team. So where we're at today is that FDA has made it difficult for the industry to operate in a lawful way. And it's not because of the fault of the industry itself, but it's because of the lack of actual guidance and regulations that FDA has put out to be followed. What we're here to talk about today is a few different cases with the attempt to try to give some greater clarity to those of you in the industry who are trying to make sense of where are we at now, what can be done, and in particular, in light of FDA's overwhelming denial of millions, of products, of vape products through its PMTA process. Now, I'm going to start by talking about this case you see on your screen. It's the Wages and White Lion Investments case, doing business as Triton Distribution versus the FDA. And for those of you interested in appealing your PMTA denial, if you received a marketing denial order, this case actually holds some key arguments for going back to the agency and saying, hey, we deserve a fair shot. We deserve that you actually look at our material that was submitted. It was submitted in line with what you had put out as being required for submission. And we deserve that you actually look at it. And in accordance with your guidance, where there are deficits, you come back and ask us to provide this information so that you can fully evaluate our application. As we know, FDA oftentimes simply looked for something, generally speaking, known to be clinical studies. They specifically referred to something called a longitudinal cohort study, or a randomized control trial. And where they didn't find it, they simply went ahead and denied PMTAs left and right. After I finish up talking about the Triton case, then Jacob will be speaking about two important cases, one of which is called Electric Clouds versus FDA, and the other is called Loper Bright Enterprises versus Raymondo. And you can think of that one as the precursor to what might be a potential overhaul to what's known as the Chevron Doctrine, which simply says courts, when you're listening to a case and it involves a federal agency who's made a decision, you must defer to that agency's decision making, right? The idea being that they're the expert in terms of this subject matter, this area of law, and this is why they have created the regulations and have the enforcement authority. A decision on the Triton case came down just earlier in 2024. And this case had been going on for a handful of years at this point, having involved two companies, Triton Distribution and Vaptasia LLC. Both of them had submitted PMTAs. Those PMTAs included long-term controlled and peer-reviewed studies to show that e-cigarettes generally helped existing smokers switch to vaping. They also included extensive marketing plans. Those showed that they had designed restrictions to prevent youth access, which of course is the big concern that FDA has. They also intended to sell only to age-restricted locations, something that vape shops were very good at safeguarding. And I use the word were very good at because so many of them have closed since FDA's actions. They also implemented strict age verification methods, and they restricted their marketing to age-restricted channels. Now, FDA went ahead, after looking over what they had submitted and denied their PMTA. And the court found that FDA's decision in doing so was what is known as arbitrary and capricious. This is a term used to describe the actions of a government agency which is unreasonable or which is without a basis for making such decisions on established standards. The result of this is that their MDOs were no longer applicable, right? So they could actually keep selling their products, and that FDA was now in a position to review their PMTAs in accordance with those instructions which had been set forth back when they submitted them. And understand this was back in 2020. Okay, so we're 4 years out at this point. Now, the court used 4 principal administrative law principles to show that FDA's actions had lacked reason. And I'll go through the list of them before describing each of them. The first is something known as post hoc rationalizations. The second is that of the fair notice doctrine. The third is what's known as the change in position doctrine. And the fourth is the good faith reliance doctrine. Starting with post hoc rationalizations, these refer to justifications or reasoning for making a decision after the decision has been made, without being part of the original decision-making process. FDA originally emphasized the importance of marketing plans for a successful PMTA. It later then revealed that the agency had not even bothered to evaluate them. Then, while before the court, FDA's lawyer suggested that the agency did evaluate summaries of the applicant's marketing plans. This inconsistency, however, raised concerns about the fairness of FDA's decision-making process. The second principle is the fair notice doctrine, and this requires that government agencies clearly communicate their rules before penalizing anyone for not following them. FDA's guidance initially suggested that some types of studies may not be necessary for e-cigarette PMTAs. Later on, it changed its position and gave additional requirements for long-term studies, scientific studies on flavored e-cigarettes. Now, this had not been clearly communicated to applicants beforehand. The court also criticized FDA's rejection of existing scientific evidence from non-flavored e-cigarette products in PMTAs for flavored e-cigarette applications, as the agency had previously indicated that such evidence would in fact be considered. FDA's failure to provide clear notice regarding changes to requirements unfairly penalized manufacturers by denying their PMTAs, even though they had carefully followed previous guidelines given by the agency. So this is what the court had found with the second principle. Under the third principle, which is this change in position doctrine, the court looked at this doctrine, and it requires agencies to provide a well-reasoned explanation for why they change their policy or standard, especially if the change contradicts prior policies. The court found that the FDA failed to justify its reasoning for the change in requirements for PMTAs, especially when it came to the scientific studies and marketing plans for flavored products, right? Of course, flavored products are really what's at the heart of FDA's concern, not tobacco. And really, it's only not tobacco. Now, the court found that this lack of justification again raised concerns about the fairness of FDA's decision-making. And I just want to pause here because I know from talking with a lot of our clients and a lot of manufacturers in the industry that they just felt like it was unfair what FDA had done. And you may feel like that too. We agree, by the way. We also think it was unfair. We know how much time, effort, energy, collaboration, and of course, resources, including money, was spent on preparing these applications. The industry did not take this task lightly. And then to just have a blanket, everybody across the board is denied, it was not only disappointing, but it was insulting. The fourth principle is the good faith reliance doctrine. And of course, all these people in the industry who did put all this time into preparing these, they did rely, in good faith on what FDA had put out. This good faith doctrine, it ensures that those who follow rules in good faith that were set out by government agencies, will not be punished for following those rules. The court criticized FDA for its complete disregard of its own guidelines, the guidelines for manufacturers, and for its failure to consider crucial aspects of the applications, especially the marketing plans. Now, despite the applicants following the guidance, the agency's sudden shift in requirements without proper justification undermined the applicant's ability to have their own PMTAs fairly reviewed. So the court's decision to overturn these denials, the FDA's MDOs, led to it ordering a reevaluation of the PMTAs. And this is something that we consider a significant victory for the industry because it's now opened the door for other PMTA, those who receive denials on their PMTA, to take the FDA, take its decision and say, hey, we have the reasoning from this case. And we do, we're actually working with some clients on this where we have a handful of key points that we're arguing in our client's favor, so that they too can have an opportunity, a fair shot at actually having their application reviewed because it contains the requirements required back in 2020. Now, of course, nothing is ever perfect, especially when we're dealing with the FDA. And so along with the Triton case, there have been other cases being heard across the country in different courts, and not all of them agree with Triton. So Jacob is going to go ahead and talk to those cases at this time.
Hi, I'm Jacob Lundy, as Deanna mentioned, also with the Clark-Esposito law firm PC here in New York. And I'm a legal analyst with the firm. And so a lot of what I do day to day is to monitor decisions like the Triton case, and unfortunately bring the bad news that Triton is not the end of the line. Of course, around our office, we love the Triton case because it's a very thorough analysis of FDA's review of PMTAs. And we think that Triton has a lot of weight to it. We think that Triton is an important case for the vapor industry. And I should note that in Triton, the court referenced vapor industry as a whole, not just the vapor manufacturers in the Triton case, but the court mentioned that vapor manufacturers across the U.S. acted in a similar way based on FDA's rules at the time and their guidance. But as we noted in 2023, for about the past year to 16 months, FDA denied somewhere in the neighborhood of 1 million PMTAs. So there are appeals all throughout the U.S., and I think we found that there were active appeals for PMTA denials in something like 8 circuit courts of appeals just in the past year. So no sooner do we get through analyzing Triton and beginning to think about next steps with the Triton decision that we see in the 10th Circuit U.S. Court of Appeals, Electric Clouds Incorporated combined case with Cloud9 Vapor. In that case, unfortunately, the 10th Circuit Court of Appeals ruled unanimously in favor of FDA. So that's not all bad news. We say that just to say that there's a lot of mixing of decisions throughout the circuit courts. And for the past year, everyone's sort of been waiting for what's the case that's going to make it to the U.S. Supreme Court. I am of the opinion that the Triton case will be the straw that breaks the camel's back. There's a lot of mixed opinions, mostly in favor of FDA, but I think Triton was so thorough and in favor of the vapor industry. And again, it spoke to how the vapor industry as a whole operated, that will be the one that gets through to the Supreme Court. And it's worth noting that in that case, predictably, the FDA is actually the one that petitioned the Supreme Court. So probably better chances than not that heads to the Supreme Court. So as Deanna mentioned, we're going to talk about one last case that's on a little bit of a different topic. Up to this point, all the cases we've mentioned have been vapor manufacturers who have been directly challenging FDA's review process for PMTAs. But the next case is a much broader issue with the way federal administrative agencies in general operate. And specifically, the case I'm referring to is Loper Bright Enterprises versus Raimondo, the U.S. Secretary of Commerce. And what this case is doing is challenging the way that U.S. federal agencies have been operating since 1984. And that year is important because that was the year of the Chevron U.S. Supreme Court case. So in 1984, the big question the court had to decide was, what should these federal administrative agencies do where there is a statute, a law passed by Congress that's a little ambiguous? And what the court decided in 1984 was that due to the expertise and just some operational considerations, is that as long as they were acting reasonably, these federal administrative agencies should be granted some deference, as it's known, Chevron deference, or latitude in the way they operate. And this recent case, Loper Bright Enterprises versus Raimondo, is just flat out asking the Supreme Court to toss the Chevron rule, which would fundamentally change the way that federal administrative agencies operate. And this certainly has big implications for how FDA tackles vapor regulation and will impact how the vapor industry generally operates. Now, I think we should mention with regard to the FDA and the vapor industry in particular, the Chevron deference in this case, this Raimondo case that's challenging the Chevron doctrine at the Supreme Court right now. And this was argued just this past January 17th, 2024. This will be particularly interesting for the vapor industry because FDA has frequently benefited from Chevron deference. It's kind of the nature of the Tobacco Control Act. And FDA regulates this really broad set of sectors, food and drugs, cosmetics. And I think there's just inherently a lot of wiggle room in the statutory law that governs FDA. And that doesn't mean that FDA benefits from Chevron deference more than, say, any other federal agency ever, but certainly it has come up a lot in challenges to FDA's regulatory authority. And we found an interesting paper, some of the reviews we do internally in the last couple of years, a paper in the Food and Drug Law Journal did a review of cases invoking the Chevron doctrine between just the years 2000 and 2022, and found 26 cases involving FDA, where the Chevron doctrine played a part, and a pretty significant number cited in favor of FDA. So the outcome of this current Supreme Court case, Raimondo, will be something, will have some impact for the industry. So, of course, it's something we monitor, and for the time being, it is a little bit of confusion for the industry as we wait to see how it pans out. Now, what I've just said doesn't mean that Chevron always rescues FDA and allows FDA to do whatever it wants. And that was one of the reasons we really liked Triton, was the court was really reining in FDA in the Fifth Circuit. So there was a Brown and Williamson case, and I think our audience is probably familiar with what has become a fairly famous case, the Cigar Association of America, where they had a big victory against FDA, and the district court in Washington, D.C. essentially just pulled premium cigars from FDA's regulatory authority. So Chevron doesn't always rescue the agency, but whatever the outcome of Raimondo, if it's a significant alteration to the way Chevron works, or if it just completely overturns the Chevron case from 1984, that will have some big impacts on industry. And while that would be, I hesitate to say favorable, it certainly, Chevron doctrine gives FDA a lot of latitude to regulate the vapor industry, but it will create a lot of industry confusion. FDA will have to go to the drawing board with the way it does a lot of things. But it's something we watch very closely, and we'll be very anxious to see the outcome. That was just argued January 17th. So the Supreme Court has a little time to develop their opinion, and everybody's anxiously awaiting. So we will certainly have an update when that comes out. Now, everything we've said up to this point obviously gives the impression that there could be quite a bit of confusion for the industry, the vapor industry, on where it stands with FDA regulation right now. And while we'll say when it comes to PMTAs and FDA's process for reviewing PMTAs, we understand the confusion, and we understand that there's a little bit of a waiting game while we wait the outcomes of cases like Triton that appear to be destined for the Supreme Court. And of course, on the broader view of Raimondo and whatever its ultimate effect is on Chevron doctrine. However, this uncertainty as it relates just to PMTA, it shouldn't be taken to mean that vapor manufacturers and other operators in the tobacco and vapor industry can just disregard their regulatory compliance obligations in general. There are a lot more FDA rules over tobacco and vaping products than just marketing authorization. And so I think our big caution with this, whatever your plans are in the near term with either appealing a marketing denial order for a PMTA or waiting for some of these cases to play out, is our big advice is don't drop the ball on your other regulatory compliance obligations and end up subject to an FDA enforcement action. I think I would remind our audience that FDA enforcement is really tailored around repeat offenders and people who are sort of blatantly violating FDA regulations in general. And so we would say to our audience, don't become an FDA target in thinking that all these cases have just wiped the slate clean with FDA regulation. So with that advice in mind, I'm going to give this back to Deanna for a couple of closing remarks. And I wanted to thank our audience for spending time with us today.
So picking it up from where Jacob left off about why compliance still matters, I want to point out that compliance is both doing all the right things to not be on FDA's target. It's also doing all the regular things that simply need to be done. So if you're new to the industry or you're setting up a new location for your industry, there's the establishment registration. There are the labeling rules. There are the marketing rules. There are the manufacturing standards. Right now we have a draft set of the tobacco product, the good manufacturing practices that FDA has laid out, which different companies have been coming and providing their comments to. But this is what will ultimately be governing the manufacture of what FDA calls ends. So there's that. There are the requirements related to exports. There are those other country requirements, right? So in operating in this industry, it's not just, it's FDA, we have to pay attention to FDA. For any of you who have expanded to foreign markets, since you've got a lot more leeway to sell into other markets as long as you comply with their laws. FDA is, for the most part, hands off. So, there's a lot of other compliance related things to bear in mind. And because of that, we wanted to go ahead and give all of you who are watching a couple of bonuses for staying with us till the end. Our first bonus is this sheet here shown in the top image. It's 10 essential tips for legal compliance in the vapor industry. The second bonus is actually a legal compliance checklist. By going through this, you'll be able to understand how compliant are you. And we've got the QR code up here for those of you who are not familiar with or prefer not to use the QR code. Directly beneath it is a link to where you can find this bonus as well with the bit.ly Vape Law Bonus Clark-Esposito. That will also take you there. All right, so when you scan the QR code or you go through the bit.ly, you're going to come to a screen that you see here on the left-hand side of your screen. And towards the bottom is a big purple button that says, click here to get your bonus. You're going to go ahead and click on that button. After you've clicked that, you'll get this pop-up on your screen. And in it, you'll go ahead, put your name in, put your email and your company and your title, and click Get Your Bonus Now. Once you do that, you'll be redirected to another page where you can download the bonus by pressing the Download Bonus button. And in this single download will be both of these documents. Okay, so you'll get the tip sheet along with the legal compliance checklist. As a reminder, I'd mentioned before that we have our YouTube channel. And of course, there are lots of videos there, as I mentioned, related to the industry, related to selling your goods to broader markets overseas, and other informational videos. Head over there. Our YouTube channel is Clark-Esposito Law. You can also subscribe to our channel if you'd like to be the first to know about any new videos that we put out. And of course, last but not least, if you have any questions about what we covered in today's video, or if you have a more pressing issue and you actually need help with something, please feel free to reach out to us. You can schedule your complimentary introductory call with us. Call us at 917-546-6997. Also, if you head over to our website, Clark-Espositolaw.com, we do have a contact us form that you can fill out. In addition, when you scan the QR code and you go over to the bonus page, there will also be a section there for you to go ahead and actually schedule your own introductory call. There's a calendar there. And we look forward to talking with you. Thanks for tuning in.
Subscribe and click the bell icon so you'll be the first to know when we upload a new video. Check out our playlist if you want to see more of our videos, and comment below and introduce yourself. We'll see you soon.